committee in which we are talking with a panel of experts and then with the Courts Minister about criminal court reform. Before I ask the witnesses to introduce themselves, I will ask the members of the committee to make their declarations of interest, starting with Sir Ashley Fox.
Good afternoon. Ashley Fox, member for Bridgewater. I'm a former solicitor and my interests are on the register.
Good afternoon. I'm Vicky Slade, a member of Parliament for Mid Dorset and North Poole. My interests are on the register, but there's none of any relevance to this.
I'm Annie Slaughter. I'm the chair of the committee, MP for Hammersmith and Chiswick. I'm a non-practising barrister. I'm the patron of two justice-related charities, the Upper Room and Hammersmith Forum Community Law Centre, and a member of the GMB and Unite Trade Unions.
Good afternoon, I'm Pam Cox. I'm a former historian of the criminal justice system. I am chair of the APPG for penal affairs, and other interests are as declared.
Hello, Sarah Russell, interest as declared. I am a solicitor with a current practising certificate specialising in employment law, although I don't currently practice. I am chair of the All-Party Parliamentary Group on Access to Justice. I am a member of the USDAW and Community Trade Unions.
Good afternoon, I'm Lindsay Farnsworth, Member of Parliament for Amber Valley, former Crown Prosecutor for over 2 decades, so I'm familiar with magistrates and Crown Courts. My interests are as per the register, but of relevance to today. I'm the co-chair of the APPG on Legal and Constitutional Affairs, and I'm a member of the APPG on Access to Justice.
Good afternoon, Warren Just, Member of Parliament for Wolverhampton West. I hold a current practising certificate. I'm a solicitor but not practising, and I'm a member of the GMB Trade Union Executive Council, as well as being a member of various APPGs.
And if our guests would introduce themselves very briefly, I'll begin. We'll go from my left to right. We'll begin with Riel Carmy-Jones case.
Good afternoon. Yes, I'm Riel Carmy-Jones, King's Counsel. I'm the chair of the Criminal Bar Association of England and Wales and a barrister in the chambers of 18 Red Lion Court. I've practised and specialised in criminal law for over 30 years and also worked in regulatory law, and was lead counsel to the Independent Inquiry in Child Sexual Abuse for about 2 years, I think, with responsibility for the Roman Catholic Church investigation and the English Benedictine congregation. Most of my work has involved vulnerable victims and vulnerable witnesses. So that is very much part of my focus in considering these revised proposals.
David Ford.
Yes, good afternoon. I'm David Ford, National Chair of the Magistrates Association. I sit in Cardiff and I've been sitting for nearly 32 years now. The MA is the membership body for magistrates with around 11,500 members and over 50 branches across England and Wales. The MA is the only independent voice for magistracy and works to promote the sound administration of the rule of law. I work very closely with our policy board and 5 committees that focus on adult, youth and family courts, as well as training, learning, development and diversity and inclusion. These committees develop policy grounded in the expertise of our members. Thank you.
Thank you. My name is Kirsty Brimelow. I'm the chair of the Bar Council, which represents 18,000 barristers in England and Wales. I was formerly at Doughty Street Chambers, where I practised in crime and also in international human rights law and public law. I've over 30 years expertise in criminal law in the courts, in both prosecution and defence, and also I've had a specialism in justice systems where there's been a focus on complainants accessing justice quickly, and have carried out trainings internationally, particularly in India and Tanzania.
Good afternoon, I'm Cassia Rowland. I'm Senior Researcher and Criminal Justice Lead in the Public Services team at the Institute for Government, which is a non-partisan think tank focusing on government effectiveness. And I've been doing quite a lot of research on the performance and productivity in criminal courts and on these proposed reforms.
Thank you. If I can kick off, I think we know the position that the Bar takes, both the Criminal Bar and the Bar Council generally, in response particularly to the proposals on jury trial. Could you indicate if what differences there are, if any, between the position of the Bar Council and the Criminal Bar Association. A question obviously to either Ms. Carmy Jones or Mr. Primolo.
Yes, I mean, I'm happy to take that. It's probably the occasion where there's not even a nuance position between the Criminal Bar Association and the Bar Council, and also the circuit leaders. We all are at one in relation to the efficiencies that would have a real impact on the backlog and reduce delays, and we are all at one that reducing jury trials in the way suggested or at all would not have that impact on reducing delays on the backlog.
No, I agree. I agree with what Ms. Brimlow has said. And I would just add that 90% of the membership of the Criminal Bar Association were against the proposal advanced by Sir Brian to limit the right to jury trial. That's the same now. There is an overwhelming support for the Bar Council's suggestions and against the proposals.
What would the government have to do to persuade you that some change is necessary to the way that jury trials function at the moment?
For my part, if I can take that, significant evidence will need to be produced. There's an absence of evidence. What happens in other jurisdictions is not evidence, nor is importing piecemeal bits and pieces of what goes on in Canada or New Zealand evidence. It's also important that there is evidence that juries actually do cause delay, and as far as we are concerned, that has not been produced. We need to see the modelling, we need to see the analysis, and we need to see the core data, and none of that has been produced.
If that evidence were available, if there were, I mean, clearly you're talking about beyond what's in the Sir Brian Levison's Part 1 report, would you be persuadable that changes can be made? What I suppose I'm trying to get at is, are you saying that the system is sacrosanct as it is, that changes could not be made to the type or volume of cases that went before judge and jury now? Or are you simply saying that you need to know how far that will contribute to the government's aim of reducing the Crown Court backlog?
There's two parts to it. In fact, yes, the objection is principle, so you can say sacrosanct, but we would say principle. And then secondly, it's also pragmatic. What would be needed to cause a change, of course, if there was modelling to show that it would have an immediate effect on the backlog of 80,000 cases, then of course that would be considered, because that is what we all want. We want to reduce the delays. But we all know, and in fact the government's already said, that it will not have an impact on those 80,000 cases, because primary legislation would have to be introduced, because it is a constitutional principle. That will take time, and then that will be forward-looking. It can't look retrospectively on those 80,000 cases. And meanwhile, we have energy, focus diverted away from getting on with the remedies that actually would have an impact now on bringing down the delays.
But if they could produce, they did produce evidence, and we know there's a lot of documentation to come, legislation, impact assessments, responses to Brian Levison's report, that showed there would be, so Brian says 20% in terms of time, but if there was greater evidence that would happen, you're not opposed to the idea that there could be some redistribution, curtailment of jury trials if it would achieve that ambition?
It's still opposition, because the principle is opposed. There's only 1% of cases in any event that's before the jury. So and we know that on Brian Levison's 20%, he's looking ahead to 2029, 28, 29. Nobody is suggesting that it will impact the backlog if we look at this forensically, because no legislation can apply retrospectively. It wouldn't be possible.
It sounds to me like you're saying that even if the government could stand up figures for this being a contributing, obviously not the only factor in reducing the backlog, that a change to mode of trial could mean the backlog reducing over time, or at least not increasing, you would still be opposed to these changes because you believe there's a principle for retaining jury trial.
There's still the principle, but firstly, respectfully, it is speculation, because we all know how the law works, that it's not going to be looking backwards. So we can agree, what we can agree on is we will be looking at, will it impact on the backlog in about 3 years' time? So that would be the earliest. Now, if there's modelling produced by the government to show that there will be some reduction on the backlog in 3 years' time, of course we will look at that. However, the principled objection is, whilst all this focus is happening now on the juries, we actually aren't getting on with the efficiencies that could be brought in, because there's only so much energy and resources that people have. So that's why I'm putting it that way round, that of course any new modelling would be looked at. However, the principle is one which we very much adhere to, because there's no reason to pull it up. If the government was to say emergency legislation, a sunset clause, because it's going to reduce the backlog in 2029 by X%, of course that would have to be looked at. But currently that's not where we are.
I'm not entirely. I totally understand your point that there are other methods, making the courts more efficient, using them better, putting more resources in. You would like not only to see happen, but happen before we looked at this. I totally understand that. But let me ask Carmi Jones, would you have an objection if it were shown that there would be a reduction in the backlog, or the process would be more efficient if there were some changes made to where the right to jury trial exists at the moment? Would you be happy with that?
It's very difficult to speculate about what and how that might be shown and what the evidence would be. I agree with what Kirsty said, frankly, about principled objections. But this isn't about sentimentality. It's not about hanging on to a system because thus it has always been. Because over time, we've had a number of different reforms to the system made. Over time, there have been differences as to how juries are selected, who can sit on a jury. It's not about that. The idea that we can only comment on the proposals that we have in front of us and the evidential base for those proposals. And we don't have an evidential base at the moment.
In the interest of time, I'm going to leave it there.
Could I just, Chair, just one short point on principle. We've repeated that this is one of the moments when the public actually engages in the criminal justice system. We also see that as a very strong supporter of retaining the jury trial. You have that engagement at voting, and you have it within our administration in the criminal justice system. So we have that whole aspect of trust, which the courts still actually run on to some degree, and it's very problematic as to what would happen if we remove that community input into our criminal justice system as well.
And there are lots of important principles here, but we've had a submission for today's hearing from the Victims Commissioner that talks about trial dates being fixed in 2030, and talks about 40% of victims withdrawing from the justice process before a charging decision was made, higher in terms of sexual offences.
Yes.
Don't we have to balance the rights of victims? That's
at the investigation stage, and we completely agree with looking at the attrition rate, which has always been very high at that investigation stage. That's an answer to another question. It's what happens when it gets to the court. And looking at sexual offences cases, we need to look at when they are listed. They're always prioritised when they get to court, the sexual offences cases. However, there's a huge attrition before because of the length of time that the investigation is taking.
In there, on that point. Sorry, can I just clarify? Are you suggesting that victims don't withdraw because of waiting through the Crown Court list, and that they all withdraw before that point because of the investigation?
It probably won't be all. I mean, there will be data on this which would be helpful to get perhaps from the Crown Prosecution Service and from the MOJ. Certainly, historically, right up until now, there has been a huge attrition rate before it gets to court, and that's been where the focus has to be. But at court, as to how much it's increased on attrition rate there, the data must be there to look at.
But there are some.
Yes, there will be some, I'm sure, yes.
I think one of the difficulties is, and I in fact had heard a higher figure than that, I'd heard 60%. I think one of the difficulties is that percentage is not broken down. And to take Kirsty's point, what we don't know is how many are withdrawing immediately after the allegation. What percentage is that? How many are withdrawing because of delays caused through police investigation, through mobile phones being interrogated? How many are asked for their mobile phones, refuse, and then withdraw? How many at a later stage have a mental health crisis? This has happened in a case I'm dealing with at the moment. I have 2 complainants who have withdrawn, not because of any delays, although of course there have been some, but because they have mental health issues that have arisen and they don't feel they can go through a trial. Of course, there are some at the moment who are withdrawing because they see a trial ahead of them of 5 years to wait. Of course, there are 13-year-olds who look into the future and see that their trial may not take place before they are through their GCSEs, before they are through their A-levels. And we carry those very much at the forefront of our mind. But when you look at this issue, those delays are not delays caused by a jury. Those delays are caused by many, many other things within the infrastructure. And that is what we suggest the government should be focusing their attention on, rather than layering over a whole new Crown Court bench division and a whole new system without fixing what is there and dealing with the victims who are in the backlog.
Okay, I'm going to have to move on. Pam Cox.
Thank you. The Leveson Review states that there exists no such constitutional or common law right to a trial by jury. And the context for the report saying that is linked to Lord Justice Ald's own work on this, where he looked into the history of jury trials and the rights to jury trials and concluded that a free man's right to the lawful judgment of his peers did not refer to trial by jury. And there's a lot of academic work around that, indeed. So on that basis, Lord Leveson and Lord Justice all concluded there is no legal basis for regarding the claimant's right to jury trial as a constitutional entitlement, that is, an entrenched right overriding all other legal instruments, or as a right at all. What do you say to that?
Well, I defended in the case of Toomey, which I defended Glenn Cameron, and this was the first trial by a judge alone. It was an armed robbery at Heathrow Airport in 2004, and the jury was discharged under the Criminal Justice Act 2003, it's section 46(3), which, if the court was satisfied that there was a real and present danger of jury tampering, then it could be a judge-alone case. So this was a real test case of a judge-alone trial. And that went through various appeals, including to the European Court of Human Rights, and that looked specifically at, is there a right to jury trial? And certainly there's no right under Article 6.1 of the European Convention, because many jurisdictions don't have juries, and they have different types of juries in those that have. And one observation which I noted down from the European Court judgment is, I hope, helpful. They said that the jury exists in a variety of forms in different states, reflecting each state's history, tradition, and legal culture. And we say this is very important because what it's recognising is the system grows up out of the legal history of that particular country. And to Ms. Carmi Jones's point, therefore it's very crude and not actually always helpful to pick bits from other jurisdictions because their legal history and how they're set up is very different.
I'm talking about our legal history. There's a lot of talk here about there's an ancient right to jury trial, and I'm looking at that to say.
So, in answer to your question, I've never suggested myself on behalf of the Bar Council that there's a right to jury trial. I've always put it as a constitutional principle or tradition, which is obviously deeply rooted. However, members of the public probably think that there's a right to jury trial. So they probably perceive there is. Legally, constitutionally, it's a principle, I would say, rather than a right.
It's a principle that's also changed over time, hasn't it?
Yes, absolutely.
In terms of the role and remit of juries has changed over time. So the governance of juries has a history. And one might argue, whatever one thinks about the rights and wrongs of this, that this is another phase in the transitional governance of juries, which through democratic processes. Would you agree with that?
Well, the reason it would need primary legislation is because it's a constitutional principle, so it's deeply entrenched, and those arguments would have to be made to Parliament as to why that change would be coming through in legislation.
Thank you. I think that's probably all I need on that. I'll move on to the hearing note question.
Yes.
Sure. Leveson Review and government have both stressed that jury trials for the most serious, so indictable only offences, have more than doubled in hearing time since 2001. Why do you think that's occurred?
Well, I think if I can come in on this one, I think there are a number of different reasons. There's a great deal to do with the failures of the court infrastructure. There are courtrooms that are not operating. We don't have sufficient sitting days. There are a number of failures, as you know these points. There are a number of failures with delivery of prisoners, lack of interpreters, failures of equipment. These cause incremental delays to every trial. Cases are getting larger. In our view, there is potentially some overcharging, adding to complexity in indictments. There is reams of additional disclosure material now. We now have a completely different form of technology with mobile phones, computers, but we also have medical reports, GP records all across the country, psychiatric records, school records, and digital disclosure, frankly, takes a lot longer. For my part, I do not think that juries and the process of having juries has added to the length of trial significantly.
Sorry, I could just add to that. I completely agree. Just a few bullet points. The digital evidence is huge, and how it's served can be very problematic. It can be served late, and then the defence is under lots of pressure and might actually also need time even during the trial itself. The forensic evidence, since the forensic services were privatised, it's very difficult for the court to have control over the timetable that the forensic labs set themselves. And increasingly we see happening during trials that forensic evidence is coming late, it's even served during the trial. That will then cause delay because it'll need further expert input on the defence side. What we don't get on that figure on the length of time that jury trials are now taken, what we don't get from that figure is how much within that is that caused by the delays in the case starting. It's absolutely at a peak of not starting on time at 10 a.m. And but that is just that. So a 3-day trial, for example, might take 6 days, but if you're only starting at 12 o'clock every day, it would have taken 3 days.
Can I add one thing?
Could we ask Cassia Rowland to come in? Because I know the Institute of Government have made some comments on productivity of the court, and I'm very keen to hear from some of the other witnesses.
So the point I would make is I don't think 2001 is actually a very helpful reference point, because that was the year in which committal hearings for indictable-only offences were abolished. And so if you look at 2002, it's more like a 50% increase since 2002 rather than a doubling since 2001. And I think that's just a kind of the wrong reference year to look at. So it's not as extreme an increase as it might appear when you first look at it. I think if we're looking just at the time spent in hearings, rather than some of the wasted time around hearings that we know has also gone up, I absolutely agree that digital evidence is going to be part of that. Some of it is also likely to be due to delays in the system itself. So what we think of as failure demand, the failure to kind of act on or appropriately meet demand when it first arises creates more demand later on. So because you're not dealing with a case promptly, that can mean that you have maybe more bail hearings or kind of additional hearings that wouldn't have needed to happen at all if the case had been dealt with efficiently and quickly when it first came before the courts. And we can see this there have been really big increases in guilty plea cases in terms of how much time they're taking in hearing hours. And some of that is probably due, again, to sort of similar delays and not that it takes longer just because of the delay.
Could I, now you've begun, could I ask you just to continue with the other side of that coin and tell us how much time do you estimate the government's proposed reforms to jury trials would save the Crown Court, and what evidence they need to produce to persuade us of that?
I think it's helpful to think of it as two separate sets of reforms. So there's your Swift courts or your Crown Court bench division, the concept of judge-only trials, and then there's keeping more cases in magistrates' courts. The government has suggested that you'd maybe move about a third of jury trials would instead happen in magistrates' courts, and then you'd only have a relatively small number going to the Swift courts. I'm not quite sure that they'd actually manage to move a third into magistrates' courts. I think maybe a fifth is more likely at the kind of upper end of that. But you would still only have quite a small number of cases going to those judge-only courts. So the impact of the judge-only courts, I think, would be marginal. You are looking at saving 1 to 2% of all hearing hours in the Crown Court. Because while you've got, that's even if you accept that 20% reduction in hearing hours per case, it's such a small proportion of cases that applies to, that the total impact is really quite marginal.
My question was more to do with what, I think you've answered it, but in a sort of strange way, that my question was, what does the government need to do? There's a lot of criticism that the government has not produced evidence. You seem to be saying the evidence isn't there, so there's not much they can do.
I think the numbers that we've got let us make a reasonable assessment of what impact this is likely to have. I mean, I know that the review team and HMCTS have had, they've got more detailed data on what they expect demand to look like in the future that lets them make more detailed assessments. But I think it is possible to make a rough estimate of the time savings that this reform package would lead to, and I think it's pretty small, particularly for the judge-only trials aspect.
Just to clarify something, you said you estimate about 1 to 2% savings in Crown Court time. Are you just talking about how much time is saved in the actual court hearings in the courtroom, or are you taking into account other savings within the criminal justice system, like the work undertaken to summons jurors, to deal with jury expenses, etc., which obviously will have been reduced as well? But could you clarify?
Yeah, that is just the court time. Right. So there are other aspects. It might well take criminal lawyers less time to prepare for a non-jury trial, potentially. That isn't factored in. It is just the kind of court time element in hearing, and it's only for the sort of Swift courts aspect of it. It doesn't factor in moving more cases into magistrates' courts.
Would that be a more significant reduction?
I think it would be.
Your hesitation here, because there's a lot of criticism of the government for not producing methodology. Have you got methodology that backs up your 1 to 2%?
I do. I'm very helpful to take you through it, but we would be here
Indeed.
All night.
But overall, remember, Brian's made an estimate. There's been criticism that that's not well evidenced. Same with the government. Overall, what can you say, based on your evidence, would be the saving for the measures that are set out in Leveson Part 1?
I think just looking at the jury trial aspect, so not taking into account kind of appeals, out of court disposals, those kinds of changes, you'd be looking at 8 to 10% savings if they're right about how much they save per case, how many cases they can keep out.
Swift courts, having no jury there for however many cases it is, 7,000, whatever it is, cases, that's not going to make an appreciable difference to...
No.
Thank you. I'm sorry, I interrupted you.
No, I'd finished. Thank you.
Pam, had you finished as well?
I'm finished.
Lovely. You're very, very disciplined. And then we'll go on to Rinda.
Yeah, I can understand the public thinking that they would like to be tried by their peers, and Brian Leveson had actually proposed that the Crown Court bench division would be constituted by a judge sitting alongside two magistrates without a jury. And he did say that that would maintain fair trial standards. He said that this would bring in community representation and diversity that the magistracy offers. And he did also say that magistrates bring local community values and a measure of local accountability in a similar way to that provided by a jury. So if the government were to adopt, instead of having a system whereby trials take place by a judge only, if we were to have a system where there would be a judge and two magistrates, would you accept that that would be a fairer system, and would you be prepared to go along with that?
Do you like? Would you like?
For all of you.
Well, let me dive in. I wonder why. First of all, I wonder why one head taking the current proposal is better than 12, and why is it thought 3 heads are better than 12? One of those heads is automatically going to be in a position of power and authority and experience that well surpasses the 2 magistrates who sits to his side with greatest of respect to them. How well, I ask, would the 2 magistrates stand up to the judge if they disagreed? When you have a jury of 12, there's a safety mechanism because you have 12 individuals who offset against each other and bounce against each other. When you have 2 magistrates alongside a judge, that bouncing is not going to be the same. How is it going to work, and this may be a question more for David Ford, with the magistrates? Are they going to be professional or are they going to be lay magistrates? The proposal includes an increase in seriousness of cases by reference to the increase in seriousness of sentencing. That level of sentencing could include much longer violent disorder, multi-handed type cases. How are magistrates' dates going to be managed? How is the fairness of the trial going to be affected if you have to break off after a week to get the magistrate back? I've done magistrates' courts cases in the past, and sometimes when you have to reconvene the magistrates, it's extremely difficult. Certainly, you would end up with more of a balance. Certainly, you would have more of a chance of getting diversity within the group of 3, but not very much more, frankly. And you would still have people who are deemed appropriate to be magistrates, as well as those who are deemed appropriate to be judges, who may not be the kind of people you would find on a jury who really understand what not just the defendant but also the victim is going through. So it would be a little better, but not good enough.
I think I would focus in on...
I don't want to interrupt you, but I'd love to hear Mr. Ford's view.
Yes, I'm keeping my powder dry.
We have got some questions for you specifically, Mr. Ford.
Don't worry.
I'm sure.
Don't worry. We won't let you go without interrogating you.
With regard to 2 magistrates in the intermediate court, Swift Court, which we don't think is a helpful phrase anyway, because it implies swiftness over efficiency and so on and so forth. But we certainly called for, in Leveson, for 2 magistrates to sit. I do disagree, with all respect. We are both professional and lay. And we already sit with judges on appeals. And believe you me, having done it, we are more than brave enough to stand up to a judge. The votes in any retirement room are all equal, whether you be a magistrate for 32 years or 32 months. All the votes in the retirement room are the same. Of course, the judge would have more experience, but having the 2 magistrates there will give an element of the peers judging their fellow members of society, which is essentially what the judges do, what the juries do. The added benefit, of course, in the magistrates' court and presumably in the intermediate court, is we give reasons for our decisions. Now, we're not saying in any shape or form we're better, but we're different than judges, than juries. So when we come to a verdict, we explain what that verdict is, how we got to it. So we're very much supportive, and whilst we're broadly supportive of the recommendations overall, we are disappointed that the recommendations have come through without two magistrates sitting alongside a judge.
Can I just add? I mean, 90% of criminal cases are dealt with by magistrates, and I don't think anybody's going to say that they're not dealing with those cases properly. And I'm glad that you've clarified the distinction between professional magistrate and a lay magistrate. I had a friend who wasn't happy with that distinction being made. They are professional and they are lay, and that's the point that I'm making, that they bring an area of professionalism, but they're also from members of the public.
And diversity.
So, yeah, I mean, that's why I make that suggestion, but I would like to hear from the rest of the panel.
Yes. Can I go to Sarah, then I'm going to bring Lindsay in because you've got other questions, I know. Yeah.
Ms. Carmi Jones, have you appeared in the employment tribunals?
No.
Because it is absolutely, and has been, the gold standard in the employment tribunal system for a very long time that there is a judge and one member who is drawn from a traditionally employer background and one who's drawn from a traditionally trade union background. They are both lay, but it's absolutely considered to be good quality decision making in the employment tribunals. And I feel that this is a very similar system. So just wondering if you have any reflections on that.
Well, if I can just reflect on regulatory proceedings and the kind of proceedings I've been in, I've very much heard the argument, well, it's all right in regulatory and civil work for cases to be decided by a judge or a panel. The difference is that in those cases there isn't the same degree of legal application in my experience. So, for example, in regulatory proceedings where you have a hearsay application, hearsay is generally admissible. Bad character doesn't come up in quite the same way as it does in a criminal case. A judge doesn't have to put aside the 25 previous convictions that they know that are irrelevant of a defendant, or they rule are irrelevant of a defendant. There isn't usually as much argument around issues about disclosure because things that are redacted in the cases I've dealt with largely deal with mental health issues or personal data. There aren't the same kind of issues around disclosure of technical material, mobile phone data or previous psychiatric records. Those kind of proceedings also have significant delays. I did a sexual complaint allegation in the SRA a few years ago. There were 3 on the panel. It took nearly 2 months, in fact over 2 months, for the judgment to be handed down whilst everyone was waiting for it. Decisions with reasons are going to need to be very carefully drafted and considered and are going to be picked over with a great deal of scrutiny. One thing a jury does at the moment is it provides a judge with a level of protection, because when the verdict comes in, you know that 12 people have come to a conclusion around that. They've spent some time deliberating and they come to a decision. When you have a single judge or a judge and 2 magistrates providing a ruling, the detail of that is going to be picked over. It is going to be, in my view, likely that it will lead to further appeals. And there is a concern about the impact on the judiciary as a result. We already have a number of cases where judges who are easily identified in the media have been targeted by media and others as a result of rulings that are unpopular. That doesn't happen with a jury. Now, I know I'm digressing onto other topics.
I do feel you rather are, with the greatest of respect.
Well, that's why I say so. But I'm not saying that you cannot ever have a form of case where a single judge or even a panel can produce a fair result. What I'm saying is that criminal cases are different from employment-type cases. They're different from regulatory hearings. They're different from civil cases. And there are different issues that need to be dealt with in those cases.
I will beg to disagree, but I will hand over to my colleague.
Is it not the case, though, that there are already examples within the criminal courts system of exactly the two options that we're talking about? So the two magistrates and judges, as Mr. Ford has already said, is exactly the setup for appeals from the Magistrates' Court in the Crown Court. And also there are excellent, if I may say so, district judges who sit alone in the Magistrates' Court hearing cases every day, usually the more complex or more serious end of the Magistrates' Court remit. So there's already good examples of this working in practice. I'd be interested in your thoughts on that.
Well, there are good examples of what they are doing working in practice. Those aren't the same as examples of the wider proposals working in practice. It can work in an appeal case. Equally, if you speak to some of the judges who sit with magistrates or some of the magistrates who sit with judges, they aren't necessarily as satisfied by the process as perhaps it may appear on the outside. It very much depends on the circumstances, but we're talking about a different type of thing.
Can I just come in there?
We are, actually, to be fair.
Can I just make one brief comment there? I don't know where that data comes from, that judges and magistrates aren't satisfied. I sit on appeals, colleagues sit on appeals, and we all think it's really healthy. We have an added bonus. We get to speak to a judge as well. The judges' feedback to us when we sit with them is they are getting a completely different angle than they would normally look. We are more diverse, and we do add to those discussions. So it does work, a judge and two magistrates.
Chair, if I could just raise one point on this. I take a slightly different approach. And full disclosure, I do sit, and I've sat as a recorder, so I've also dealt with appeals with two magistrates. I don't take the approach of the judge perhaps intimidating in some way or being over-authoritative with the magistrates. And I agree that there's always very robust and very helpful three-way discussions. However, respectfully, I think we are slightly getting away from what we're looking at here, which is the juries and also the jeopardy at the end of it, which is potential imprisonment. And I don't find those different tribunals, again, which I've got lots of experience of, a good comparator because of the different types of evidence that have to be dealt with. What I would sort of gently ask that we go back to is the experience when we have tried it with a judge-only trial, and that is really the case of Toomey. There's been a few others, and you can look at the issues there. The question on the panel, of course, it's better having three than one judge and having the community element in there. Of course, I agree with that. However, looking at it from the jury perspective, there's no reason to actually remove that greater protection of having 12 people. And it's because the jeopardy at the end of it is somebody's liberty, not only losing their job and so on, but actually losing much, much more than that. And that's the protection around the jury, and it separates them as the fact finders with all their diversity from the lawyer who's the judge presiding. I would also say on the data, with the magistrates, I completely agree. Magistrates are a really important part of our system. They do a fantastic job, absolutely fantastic, district judges and lay magistrates. However, there is the statistic that 41% of appeals from the magistrates' courts are successful. So sometimes the justice isn't working perhaps as it should within the magistrates' courts.
Do you know what proportion of those appeals do you know the attrition rate based? I'm trying to get my words out.
Yes.
Do you know what proportion of those successful appeals are as a result of the victim or a witness not wanting to go through essentially a retrial?
Yes. I don't have that data, but I can certainly look into it and we can communicate it.
With us,
yes,
with
absolutely.
That would be really useful.
Yes.
Thank you.
We shouldn't underestimate how few people do appeal. You know, nobody's going to say the magistrates' court or any court is perfect. Of course there's going to be variances. Of course there's going to be mistakes. But invariably, the appeals are on sentence, the length of sentence invariably. But very, very few do get appealed, and it's really no surprise that 40% are successful. I don't think that's a bad thing. I think it's healthy that the appeal process is there, and whilst we're not specifically speaking about that, it's certainly something we've got. If we're going to have extended powers, I think we have magistrates are telling me and telling my colleagues that we'd be a bit uncomfortable if the appeal is taken away, the option for an appeal is taken away. And maybe that's something to explore. We don't have proposals for it, but it's something we certainly think should be thought about. Is it the wisest thing? When there are so few appeals, what difference will it make? It's an open question, it's not a closed question on that.
Thank you.
Yes, you.
Thank you. Really, this is a question for all of you, really. But the government has proposed to remove the right for defendants to elect, in either way cases, to elect jury trial, which goes beyond what Brian Levison was suggesting. Albeit, I think there was some comments that he didn't think that was a bad idea if that's what the government wanted to do. So, do you agree with that proposal to remove the right to elect?
Yes, we certainly do. We don't want, and we do see gaming going on where people have the option to, we call it either way, of course, we all know that phrase. They'll choose to go to a Crown Court with the hope that time will send the boat down the river and victims will decide to change their minds, so on and so forth. So from our point of view, we believe that magistrates are, when they're assessing either way, are probably a better judge of what's appropriate than the individual who may or may not be gaming. And certainly the more serious cases, of course, with allocation, we're already trained to do that. And if we believe it's likely to be beyond our sensitive powers, we, as we say, we'll send them up. But the removal of either way, we're certainly supportive of.
If I may, Chair, I really do struggle with the language of gaming. It's not reflective of somebody who's accused of a crime who's pleading not guilty. There's a presumption of innocence there. And certainly my experience is that defendants want the case to be heard as quickly as possible as well. Often their lives, I mean, there might be some sort of raised eyebrows on that, but having worked in this area for over 30 years, representing and speaking to people as to what they want, their whole life is just frozen until the matter can be resolved. And don't forget, many people are actually also found not guilty, or the prosecution offers no evidence, or it's a lesser plea. So I really feel that language of suggesting that it is accepted or it is proven in some way that defendants are gaming the system is not actually accurate. Undoubtedly, there's going to be some people, this is a whole vast number of people that you're dealing with. There's undoubtedly going to be some people, but I've not come across them myself.
Very quick supplementary. The right to elect has also changed over time. It's had different forms in different periods. Does that have any bearing on your thinking on this matter?
If you'd like me to answer, the right to elect, the proposals were, the flags are, of course it has a bearing in that you always want to look at what reform is there, and the Bar Council and barristers are absolutely not against reform, and we always work with it. Here, the proposal on removing the right to elect for certain low-level offences is one where we would flag caution. It is opposed because the low-level offences often are those where you have somebody of good character and they are in jeopardy as to the rest of their lives if they have a conviction. So we would place the focus on the offences themselves, on reclassifying those that should in fact be within the magistrates' court and not in the Crown Court. So look at those. So it's debated within Parliament. and the changes made there, rather than looking at changing that system. So it probably would actually have the same effect, but it means that the offences can be looked at properly on which ones should actually be within the Magistrates' Court. A very clear example of that is assault on an emergency worker, which was introduced originally to deal with assaults on paramedics. It's been used for assaults on police officers. A practical step there could be to offer no evidence in all of those cases and reintroduce assault on a police officer, and there could be actually legislation around that exceptionally where that could apply. It wouldn't be retrospectively leading, it would just be another offence which would be more appropriate. It would go straight in the Magistrates' Court as an example.
Sorry, can I just clarify with you, Kirsty Brimelow? So are you saying that you are you disagree with the government removing the right to elect?
Yes, however, with the caveat, we'd always look at what exactly is proposed. There's no specific proposal on what it would impact upon currently.
And Real Comey Jones, can I ask you the same question, please?
I think the difficulty is that it depends on the clarity about what they're electing for, and we haven't actually got a clear idea of what the cut-off point is and what it relates to at the moment. So, yes, in principle, we're opposed to it. But we can see
anything that's likely to get
under 3 years.
No, we're talking about different things here. Right. I think electing from the magistrates. So at the moment, there is a mode of trial hearing, as I'm sure you know, but just in case anybody doesn't know. So the magistrates consider representations and decide whether their sentencing powers are sufficient, and if they are sufficient, then the magistrates, and they're equipped to deal with the case, then they will say that it's suitable for summary trial. But then the defendant has the opportunity to override. So that's the only thing we're talking about. We're not talking about the Crown Court bench division. We're talking about removing the right for a defendant to override the magistrate's decision and say, no, my case is going to the Crown Court. So that's what I specifically I'm asking. So are you in agreement with that or opposed to that?
The Criminal Bar Association is opposed to that for the reasons as Kirsty's outlined. It is something that we're conscious may need to be looked at in the future.
Last year, 4,283 cases were in that situation, so only went to the Crown Court because the defendant elected Crown Court trial. So straight away, that measure means that 4,283 cases fewer would have gone to the Crown Court last year. So what would you...
It's difficult because what is the context of each of those cases, and there may have been reasons why they were advised to elect. I'm
going to have to move on a little bit, I think.
Fine. Thank you. Shall I just move on to the magistrates, I think?
Well, yes, I think Vicky's going to ask some of the questions on magistrate. Well, what I'd like to do, if you're happy to overrun by a few minutes, there's one or two further questions to Ms. Rowlands and to Mr. Ford. Could I go, I think we might brief to Sir Ashley, who wants to ask Ms. Rowlands a question, then I'll come to Vicky Slade.
Yes, Ms. Rowlands, can I just ask you, tell us your views on how productivity in the Crown Court system might be improved. I'm conscious that the Institute for Government has said that productivity of the Crown Court has declined, that the number of cases being dealt with each day is down 10% since 2016. Just put aside talk about scrapping jury trials and other stuff. How do we make our public servants more efficient?
I think one of the... there's a number of sources of productivity problems in the Crown Court. One is a shortage of criminal lawyers, that is a real problem. A significant proportion of all scheduled trials get rescheduled on the day because either the prosecution or the defence lawyer is not there. And that just results in so much wasted time. And also obviously negative consequences for the defendant, the victim, and so on. And so that is one major source of problem. And I think a lot of the government is taking positive steps on that. Things like matched funding for criminal pupilages. The Crown Prosecution Service has got a significant boost in the spending review last year that will hopefully help to kind of address some of those workforce problems. I think they need to monitor that quite closely and see if it's having the desired impact. So workforce is definitely a big one. The physical infrastructure and technical infrastructure in courts. We hear about kind of constantly, leaking roofs, broken radiators, jurors wandering around trying to find a room to sit in because half of them are closed. Those kinds of things make things really inefficient. There have been big declines in court staff. So that's down sort of 20% since 2011, roughly, and even bigger declines in permanent staff. So you've got a lot of temp agency staff, and that is potentially making it, we hear that there's a lot of administrative problems in courts. People don't know kind of what's going on, where they're supposed to be, where defendants are. Maybe the trial is waiting for a defendant to be delivered from prison, and then actually it turns out they're in the cells downstairs and there's just been a communication problem. These are all real examples. And so those kinds of just administrative problems we think are creating big delays. And the fundamental problem is that fewer hours are being sat for every sitting day, and that just means that the courts are getting through far less in any given year than they should be.
And in your view, addressing those matters would have far more of an effect than scrapping jury trials?
Yes, I think so.
Thank you.
If you look at how, once you kind of adjust for complexity, the type of case, the offence and so on, it's about a 20% fall in complexity adjusted cases dealt with every day that the courts are sitting. And I think even partially reversing that would have a much bigger impact than a lot of, in terms of productivity and efficiency and the size of the backlog, than some of the reforms we've discussed.
Thank you, Chairman.
Thank you very much. Please, Ray.
Thank you. These are primarily to Mr. Ford. We know that the Magistrates Association has come out in support of the extension of the ability to sentence for longer in the Magistrates' Court. A couple of things. One is we've already seen the move from 6 months to 12 months. Obviously, there are now proposals to go 18 and potentially 24 months. Can you just, with that in mind, knowing where your starting position is, what's the impact been, and what additional skills or considerations would need to be taken into account to enable magistrates to deal with cases which presumably will be longer, as well as having potentially a more emotional effect and a different skill set?
Yes, I mean, November 24, I think it was, when the powers were there. So you asked what was it like. Well, the training was an update for us, and there was a couple of different types of sentences and cases we were starting to hear then. But I don't think that's going to be the case for the next step. So for the last 2 years, we've coped quite well, I'd like to think. We can talk about delays, what have you, in a moment perhaps. But we've coped really quite well with the additional sentencing. Yes, it's more complex. Yes, it's of a longer nature. And yes, there are emotional commitments to it as well. And certainly in the Magistrates Association, we really do try and look after our members with things like support lines and so on and so forth. With regards to the 18 and potentially 24 months, we're not aware yet, certainly, of any new types of offences that would be then embraced. But they would be more serious cases of the type we're already hearing. So there would no doubt be an expectation for a top-up of training. We don't think that would be problematic in any shape or form. Of course, we're reliant on the Judicial College for that, but magistrates will welcome that. Already in youth court, and I'm a youth magistrate as well, we can sentence up to 2 years for youths, which transferred to adult would be equivalent to 3 or 4 years worth sentence. So it's not something we're not used to, and it's something we'd embrace. Ultimately, as magistrates, if we can help the Crown Court backlog we're more than pleased to do so, which is why we were talking about some of these issues about either way and other things. We're there, and I think a lot of the proposals are a vote of confidence in the magistrates, which is pleasing to see.
If you're going to be taking a case which would have a sentence of potentially 2 years, presumably that is going to be a trial over multiple days, and therefore if you're dealing with people who are volunteers and potentially are only volunteering for a small number of days throughout the year, what do you think the impact on the working patterns are going to be able to find magistrates who are willing to sit day after day after day, because they're presumably doing this alongside either a day job or they're retired people who are not planning on working a full working week?
Okay, I can respond to that. There's no suggestion that we're going to be completely overwhelmed with multi-day cases with an 18 to 24 month. As I said, far as we can see at the moment, there's no different types of charges coming before us. So the charges we'll have will be the same. The evidence may take longer. Yes, if there's going to be, we already know before a trial starts when it's listed, whether it's likely to be for more than 1 or 2 days. So of course we then will need volunteers. But we have people working for themselves. We have teachers, lots and lots of different diversity of people who at different times of the year can help more than 1 or 2 days. You're absolutely right. Less diversity if you're sitting on the intermediate court and on a longer case, because not everybody can.
Can I just give you an example? I was recently due to be a witness in a case of harassment, and the expectation was that this chap might get a year to 18 months. He previously offended and had a suspended sentence. It was listed for an 8-day trial. As a witness, I was expected to hold 8 days. It might be very well for the magistrates to say, well, I can handle this, but the lawyers, if your client is likely to be seeing 2 years behind bars, surely you're going to be calling, if you're a defence lawyer, you're going to be seeking to provide a lot more evidence, aren't you, if it's a longer sentence? I just am worried that actually it's not necessarily in your influence as a magistrate how long it lasts, but probably more likely in the lawyers going, well, this is a 2-year case. We're going to put a lot more into this, and we're going to see an elongation of cases, which I'm just not sure how that's going to work in a volunteer system.
We review cases as a matter of course going through the process. So we have pre-trial review. So we estimate with all parties involved of how long we think it will take. Obviously each case on its own merits, and some things you can't second guess. But by and large, it's fairly accurate. Time is reserved for the trial, a certain amount of trial, and you wouldn't put a magistrate in who couldn't do that commitment. If it was a long commitment, you're absolutely right. It's going to be a limited amount of people who can do multi-days. But how much that will happen, I think we're just guessing a little bit, because we don't know.
No, you're right. And the final thing I just want to ask plays a little bit into that diversity piece. We know there's currently a recruitment drive. There was a recruitment drive in 2022 to attempt to recruit an extra 4,000 magistrates. To date, it's only recruited 2,000. What do you think the impact on the diversity of your magistrates will be if those magistrates are going to be needing to sit for longer? Because, as you say, you're not going to expect teachers to give schools to give up teachers for weeks on end.
I was thinking of summer holidays in that reference.
Yeah, but it is only the summer holidays,
yes.
And let's be honest, then you haven't got witnesses available or other people available. So my instinct is saying that the diversity of a magistrate's is going to shrink back to the traditional older, person, and therefore the whole point of having lay people from the community that are more diverse might be lost. Or what's your thinking around that? I'm getting some indication from others that may be the case.
I'm not surprised. I think you're absolutely right. I think there's going to be a challenge to recruit more people. What's changed, certainly from our point of view, is we're a lot more involved now, working alongside and with the MOJ and HMCTS. So we're putting a lot more input, because we totally agree with you. We want, even though the magistracy is already the most diverse section of the judiciary, we want it to be more diverse, and particularly younger employed magistrates. So we want to bring the magistracy into even more representation of society, but that comes with challenges. It does come with it needs employers to be willing. It needs there's an awful lot that's needed for there. So it's not just recruiting people, it's shortening the process, because it has taken up to 2 years. From the time you register an interest to the time you're sitting is 2 years. That's reducing massively, and I know the MOJ have got a lot of plans in place and stuff already starting on that with Pathfinders, which is a type of recruitment process they're using to really shorten the process. So it's recruit and retain. I think it's a double-edged sword. But with that, and the panel members, I totally agree with them. We need the infrastructure. We need the legal advisors. We need the ushers. We need everything there. We need probation. So it'll only work if everything's concurrent. It won't work if we just go and get 4,000 magistrates
final
tomorrow.
Question then. If you were handed your 4,000 magistrates tomorrow and this came in, would the magistrates system be able to cope? We know there is a modest increase in the number of legal advisors coming through, but with everything else we know about, and I know you want this to work, so I understand that position, which is different from others. Do you think it can work if it was to come in with all else being the same?
If your question is tomorrow, absolutely not. But that's in reality, we've been talking about 2 or 3 year lead.
Yeah.
So when it's phased in, which is what is going to happen if it happens, whatever happens will be phased in. Well, yes, I think it can happen. We really do believe that, but only if the other elements I've just said happen at the same time. We need the courtrooms, we need everything else as well, as the panel members have said.
Thank you very much. Now, I'll let you have the last
Sorry,
word.
just quickly, because a lot of the points I was making about productivity in the Crown Court do also apply to magistrates' courts, and I think it's really important to make that clear. We've seen activity in magistrates' courts dropping off quite significantly, kind of fewer trials happening, and so on. And I think that there is a risk that you will end up just moving the problem from one part of the system to another. I'm not making any claims about value for money or anything like that. I'm just saying in terms of the level of cases being dealt with in magistrates' courts and things like that hasn't kept up.
Can I just make
one sentence?
The delays in the magistrates' court, not in numbers but in time, is probably about 6 months. In 2010 it was about 4 months when we had double the amount of magistrates. I'm sure, and I agree, that a lot of efficiencies, a lot of it based around legal advisors or lack of. But I think it's fair to say, if you look at the delays in the Crown Court, a percent from there is not the same percent moving into the Magistrates' Court. So if you took 10% of the work at the moment from the Crown Court, that would equate to 1 or 2% perhaps in the Magistrates' Court. So it's about proportion. It's about proportion. So the Magistrates' Court.
The agreement for Miss Rowland. So
there we are. We're all in agreement. You've got your evidence.
Wind up this first session. We have overrun. I'm not surprised. We've got 4 very expert witnesses. I'm going to wind up. I'm going to take a 2-minute break to allow the panels to change over and the Minister to come to seat. Of course, you're very welcome to stay and listen to us. Attempt to put your points to the Minister if you wish. If you wish to go, then please do. But thank you very much for your attendance today. As I say, we'll start again at 1:45. Order. Order, and we resume this afternoon's meeting of the Justice Select Committee, and we're delighted to be joined by the Minister of State. I will just ask the new panel of witnesses to introduce themselves, perhaps starting with Sarah Sackman.
I'm Sarah Sackman, KCMP. I'm the Minister for Courts and Legal Services in the Justice Department.
Chris Drain, I'm the Director of Analysis at the Ministry of Justice.
And Amy Randall, I am the Policy Director for Courts and Victims at the Ministry of Justice.
Thank you very much. And if you're right, we're apologies for starting late, but I think you were here to hear the panel, and it was all good stuff. The previous panel that they were saying, but we will get straight off into questions to you. If I've understood your position, Minister, from the debate in the Commons last week, and indeed from what the Lord Chancellor told this committee on 16th of December, the proposals, the proposed changes to mode of trial, to jury trial specifically, that are both in Part 1 of Leveson and what you've indicated you would like to do subsequently, you believe that they have merit in themselves and they would be going ahead even if there were no issues around a Crown Court backlog. Would you just like to confirm that?
I do believe that. I believe in the idea that decisions about mode of trial should rest with the court, not with the defendant, as is currently the case. And these proposals, which are born out of the Independent Review of Criminal Courts, led by Sir Brian Leveson, support that proposition, which we will be bringing forward in proposals which would remove the right to elect, much in the same way, and the analogy I often use is the healthcare one. It's the approach to triage. If you present yourself in a healthcare setting, it's the healthcare professional, the doctor or the nurse, that decides where you need to be seen, whether by the GP, urgent care, or in A&E. And similarly here, where we have a finite resource, including one of our most important resources, the access to jury trial, that the allocation of that resource at the mode of trial is determined by the court, expert in matters of criminal justice, rather than allowing the defendant to insist on that choice. Now, let me just say one more thing, which is I'm not going to pretend that we would be having this committee hearing if there weren't a crisis. It's a crisis that you explored in the previous session, one which, if we do nothing, will see the Crown Court backlog hit 100,000 cases by 2028. And the impact that that is having on confidence in the criminal justice system, on victims, and indeed of those accused of crimes, is appalling and intolerable. So doing nothing is not an option, but it's about turning a crisis into an opportunity, and it's why we commissioned the Independent Review on Criminal Courts to look at the whole of the criminal court system to propose once-in-a-generation reform. But when I said, would we be doing this anyway, there is a principle underpinning it, which is that notion that decisions about mode of trial and how we approach and rebuild a sustainable justice system for the 21st century, that is determined by the court, not the defendant.
Yeah, but this is probably, isn't it? Because we've just heard the evidence from the Institute for Government that the changes to mode of trial, in the sense that cases, perhaps half the cases currently tried before a judge and jury would now be before a judge or even a judge and two magistrates, might save 1% of time in the Crown Court. The other controversial measure, you mentioned mode of trial, but I'm mentioning more controversial measures, the increase to 18 or 24 months magistrate sentencing, that might save some more time. I think the figure we heard was 8%. But these are not, again, to quote the Institute for Government, the most significant changes, are they? The other measures, greater efficiency, more resources, that's what's really going to bring down the backlog, isn't it? So are you detaching the changes to mode of trial from the backlog? And if you are, what is the inherent merit of not having a jury or of magistrates doing the majority of the sentencing?
I'm trying to do the opposite. I don't think we should detach any one of these measures from the overall objective here, which is about building a criminal justice system fit for the 21st century. And why I say that is because The last time that any government looked at reform of the criminal justice system in any significant way was back in the 1970s when the Crown Court was established. And as you heard from the previous panel, the landscape of criminal justice has changed considerably since then. The example was given of the advent of digital evidence and the way in which that's transforming criminal trials. If you take cases brought by the Serious Fraud Office, back in 2010, the average number of documents in an SFO case was about 2 million documents. The largest case the SFO currently holds contains 48 million documents. I mean, that's obviously an extreme example in the context of fraud and serious financial crime, but it's illustrative of the way in which criminal justice has changed. And you ask me, are you asking me to detach certain measures? Far from it. Sir Brian Leveson and his team were very clear that what their proposals amount to is a package, not a pick and mix. It's the interaction of the different reforms that we're proposing that achieve the pragmatic aim of bringing down the backlog, but also critically, and if you allow me to finish one more sentence, ensuring that what we end up with is not just backlog back down to sustainable levels, but being able to sustain that in the face of growing demand. So what the MOJ data shows is that demand coming into the system is not only high, but it is growing. More arrests, trials which take longer because of the changing nature of forensic evidence, digital evidence, and the supply and demand under the current system is out of kilter. And it's that we've got to correct. And it's the interaction of the reform package with the efficiencies and the investment that is necessary that is going to realise the objective here, which is a modernised reform justice system.
I understand. I don't quite understand the methodology of that. Perhaps we'll come on to that in other questions. But I think the second part of my question was, do you want a justice system fit for the 21st century? Why is that? Putting the backlog to one side for a moment, why is that a justice system with more power in the hands of magistrates and less use of juries?
It's one where I come back to the, I suppose there's two principles underlying that. One is how you proportionately allocate the limited resources within any justice system. And we know that currently magistrates process and hear 90% of criminal cases. And after the proposals, they will hear a good deal more, but it's about where you draw the line. And we have heard about the way in which those cases are dealt with robustly and fairly. It's really important that when we talk about the changes to jury trial, that part of the purpose of this is to ensure that jury trial is preserved for the most serious cases and that those jury trials can happen in a timely fashion. Swift justice is an integral ingredient of fairness, and what we're proposing is aimed at achieving just that. We already put our confidence in magistrates, and as we heard from the previous panel, the Ministry of Justice and the government has confidence in that system. This is about a bold, yes, but relatively modest redrawing of the line to calibrate the system so that it can absorb the increased demand, deal with complex and more serious cases at the appropriate level, and achieve what currently we are very far from. I think there is a consensus, and I actually heard it on the previous panel. We may disagree about what the solution is, but I didn't hear anyone disagree with the diagnosis of the independent review, which is that the current criminal justice system is broken. And I will not sit idly by and allow it to run completely out of control.
Are you where we are expecting, and if you can give us a date or a rough date, that would be great, a lot more information on this. We're expecting to get Sir Brian's Part 2 report. We're expecting to get your response to that. We're expecting to get a bill, an impact assessment. When can we expect that? And will it include the evidence which shows how far all the measures currently proposed by the government or Sir Brian will impact on the backlog?
will do all of those things, Chair, and it's important that it does, and it's important that Parliament gets the opportunity to scrutinise this. Whilst I stand by the point that it is right that we rebalance the interests of justice when it comes to determination of mode of trial, so that that rests with the court rather than the defendant, ultimately we must bring back down the backlog, and I can assure the committee we would not be bringing forward this package of proposals if we didn't think and had not tested and modelled that they could work to achieve the objective of bringing down the backlog in relatively short order. My objective is that we see the backlog coming down by the end of this Parliament, because we owe it, particularly to victims, that they get swift justice.
Will you allow this committee to undertake pre-legislative scrutiny of the bill?
We will, as is usual practice, provide Parliament with the impact assessment, which will include modelling, equality impact assessment. It will include our formal response to Brian Levison's reports, and no doubt as part of that this committee will be able to scrutinise what the government is putting forward, and will no doubt give its view on whether it thinks that these proposals cut muster or not.
I didn't quite hear a yes there, but I'll pause that moment and go to Sir Ashley Fox.
Minister, the Institute for Government has said that the proposed restrictions on jury trial are not necessary to turn around the performance in criminal courts. And I saw you at the back of the room when Cassia Rowland was giving her evidence. She detailed numerous other things that should be done, and to that extent, your proposals on jury trial restrictions are largely irrelevant to the backlog. What's your evidence that the Institute for Government is wrong?
Well, first of all, I've not seen the Institute for Government's paper. I have huge respect for the Institute for Government, but I think what Cassie Rowland said is that in her view, on her evidence, and I've not seen what she's based it on, the savings that would be realised through the legislative reforms amount to 10% savings in terms of hearing time, sitting days. I'm not quite sure which she was referring to. Well, even on her own case, that's not insignificant. But what she did say, her contention is that that is less significant than the savings one can achieve through efficiency and productivity savings.
Correct.
That is that contradicts the conclusion of the independent review, which I've considered and have to take very seriously, because the conclusion that Sir Brian Levison, David Ormerod and their team reached is that we are not going to bring down the backlog without structural reform. You need to do the efficiency part too, and you need significant investment in additional sitting days and in other parts of the criminal justice system. But Sir Brian's clear conclusion is that that alone will not achieve the outcome that we all want to see. Where I actually agree with the Institute for Government is that their insights into the declining productivity of our criminal justice system are well observed. It's a function of a system that is broken, that it becomes less productive, it becomes a sort of vicious cycle, if you like. And the sorts of things that she pointed to, investment in the workforce, the amount of time lost because there aren't enough lawyers to prosecute or defend, as she fairly acknowledged, is something the government is doing something about, with the match funding of pupilages, significant investment in legal aid, both for solicitors and barristers, to make a sustainable pipeline, just to give one example. But of course, that takes time, and time is probably the one thing
Your proposal is going to take time, because the Lord Chancellor has confirmed that these proposals won't have retrospective effect. We've got some parts of the country that are booking trials in 4 years' time. So if you take a year to present your legislation, I think the Lord Chancellor said the autumn of 26, if we imagine it takes a year to get through Parliament, assuming you don't U-turn, which I imagine you will do, but let's assume you don't, this new system won't even start until 2028. So the idea that restricting trial by jury is going to have a meaningful impact on the backlog is simply not true, is it, in this Parliament?
Well, let me answer that in stages. First of all, we are dealing with a acute crisis, which is a systemic challenge, And the government's position is that the only way to address that is from multiple angles that comprise structural reform, the productivity savings of the sort that the IFG outlined, in addition to record investment in sitting days and workforce. It's the interaction of the three things.
Well, that nobody disagrees. It's trial by juries that we're talking about. And my view, and I suspect the view of most people here, is that's just not relevant. And it's not going to take effect until 2028 anyway.
Well, I'll address that point in a moment, if I may, because it's an important one. It is the interaction of the major reforms that are proposed here, the increase in the sentencing power, the removal of the right to elect, the modification and the introduction of a permission stage to appeals, and the existence of the Crown Court bench division. We like as parliamentarians to isolate and hone in on the CCBD, but it's the interaction of how those work, and in addition to the time that can save, which the independent review and our own model will support. It's the behavioural effect that has on participants in the system. One of the things that was mentioned earlier was the declining rate in early guilty pleas. If you know that your case is going to come on quicker within a Crown Court bench division, that of itself, it is possible to anticipate will alter behaviour and therefore bring down the backlog quicker by encouraging early guilty pleas. Obviously, no one should feel guilty if they're not in fact guilty, but we do want those who are guilty to plead at an earlier stage without the need for multiple hearings, which adds to that delay. In terms of when the changes will kick in, you're right that in the context of the crisis, and I don't use that word lightly, that we're in, that we cannot delay in terms of how the measures are brought in. And just to be clear, you make a good point, which is that if we were not, having established these proposals, assuming the bill goes through Parliament, it will be important that the changes are applied to cases where the trial hasn't yet commenced within the Crown Court, but they may already be within the system, if you like. And so that means that the implementation of these measures will take effect sooner than I think your question to me suggested. It's not as if every case in the backlog...
So a case that's been committed for trial at the Crown Court, you will re-look at those cases and push some of them through the Swift Court.
I think that is something we have to look at.
So when the Lord Chancellor said it won't be retrospective, that wasn't a wholly accurate answer.
Well, I think the answer that he was giving was in the context of a case, in the question around the impact on remand hearings, and I think that was the context in which he may have addressed that.
He said the changes wouldn't be retrospective. And now what you're giving me is a slightly different answer, because if someone elects to go to the Crown Court at the moment, it's on the assumption there'll be a trial by jury. What you're saying is it might not be, you might be diverted to the Swift Court.
That's right.
That's what you're saying.
That's right.
Okay,
yeah.
So that I think is fundamentally different to what the Lord Chancellor said a few weeks ago.
That is the position, because that is the mechanism for pursuing the what was needed, which is the urgent implementation of these changes.
Because the Lord Chancellor might well have been confused.
Seek some clarity before you move on, because I wrote down during the last session that our previous witnesses made it very clear that these changes would not apply retrospectively, and therefore they would have absolutely no impact on the backlog and would not start to really make any difference till 2029. I may have missed that being said previously, but I think that was very, very strongly said. So if there is any ambiguity about whether or not these measures are retrospective or not, I think that does need to be resolved. I wonder if it's possible to ask for us to perhaps get a follow-up letter to confirm.
I can certainly provide a follow-up letter, but just to be clear, I mean, I don't know that I regard retrospective as quite the right term here. If the trial, no one's suggesting that a trial that has commenced or that has gone past
if
PTPA.
You've been committed to trial in the Crown Court at the moment,
Yeah.
you're expecting to have a jury trial. And what you're telling me is once these changes take effect, you will divert those people committed but trial not started into the Swift Court.
Yes,
Yes. And that is
if they
not
meet
what the Lord Chancellor said before Christmas.
if they meet the eligibility criteria, then that is the case.
Most people would regard that as a retrospective change.
Well, it's a change in relation to the procedure that applies to those cases. They're still getting a Crown Court trial under the new proposals.
All right. Can I just continue, Chair? I mean, given that Levison's admission that incomplete modelling was undertaken, what independent analysis has your ministry conducted to validate that judge-only trials will deliver net time savings once written judgments and appeals are factored in?
So we take as our starting point the model set out in the IRCC review and the conclusion reached by Sir Brian Levison, albeit with the caveat that you've said that in his view the CCBD would achieve at least 20%. He actually says that his personal view is that it would save substantially more time. And I can bring in colleagues here if it would assist, but we've looked at international comparisons and evidence from other comparable jurisdictions like New South Wales, like the Canadian jurisdiction, and officials have, and I have personally too, spoken to judges and those who operate the court systems in those places. Taking a step back for a moment, it is important that we are not over-optimistic for the time savings that can be realised here. And of course, we're not pursuing time savings for time savings' sake. Fair justice is essential, and we don't want summary justice for 1 second. But it stands to reason, and I had an exchange which I think, Sir Ashley, you may have heard the other day in the chamber with Carl Turner MP, who, as you know, is deeply opposed to these proposals, and he said, look, I've got no doubt that you'll save some time. And the reason that Carl said that, Mr Turner said that, whilst we disagree on the approach that the government is taking, is because of things like the absence of a need for the jury to deliberate. You have the fact that the judge doesn't need to give directions to jurors, which can often be lengthy, and the time savings involved in, as I said, deliberations and impaneling a jury. So all of that taken together, and again, it was the source of criticism by the previous panel, I grant you, but decision making between 12 people, if everybody around this committee had to decide on the facts of a case or on anything, in fact, versus yourself reaching an individual view, it stands to reason that significant time can be saved there. But what I can say to the committee is when we come to present the modelling that we've undertaken, and Chris, you may wish to come in here, on a conservative basis. We haven't, although the judges and court staff and Attorney General in Canada presented us with evidence of a 50% saving because they have judge-only and jury trial running parallel to each other. They say it saves them about half the time. We are cognitive of the fact that that's in a different jurisdiction, and that we don't want to overstate what the time saving is going to be when we present the modelling to Parliament.
Yeah, I mean, I think I would just add to that, it's obviously difficult to know with certainty in the modelling exactly what the efficiency saving will be from a reform before it's been implemented. Sir Brian and his team went through quite a structured way of trying to come up with a modelling assumption that you could use, speaking to court staff, speaking to panel of experts externally, and have come up with a sort of 20% view that is sort of broadly consistent with the international literature we have. There is obviously uncertainty around that, and one of the things that we will want to do in our impact assessment is show the sensitivity of kind of results in the impact assessment to varying that assumption slightly.
May I suggest you publish this as soon as possible, because I think making such a dramatic change to what many of my constituents regard as an ancient constitutional right to save time and then present no evidence as to the saving of that time, I think is a grave error by the government. But, I mean, that's entirely up to you. But I think you're harming your own case by not publishing what you say is this modelling and evidence.
Well, as I've said repeatedly to Parliament and to this committee, and I'll say again, of course, as is usual practice, we will be publishing the modelling. The reason we haven't done so far is quite simple, that what we need to present to the Parliament and indeed to the public is a clear, holistic view of how the reforms will work in light of the actual funding commitment and sitting day envelope that government is committed to. And we don't want to publish the modelling in isolation of that, because it's got to interact with the amount of resource that's being allocated at the same time. And of course the Concordat process, which as you'll know takes place between government and the judiciary, is yet to be finalised. At the point where that is finalised, Parliament will see the full picture and of course can interrogate it. But I do just want to push back on one.
I think that's a complete red herring, the idea that resources and the Concordat is anything to do with the publishing of this modelling. You could just decide to publish it if you chose to. You chose not to, but that's your choice. Thank you, Chair.
We're now going to move to... I should just indicate, I think the Minister's on her feet, that we may have votes shortly. That being the case, we will adjourn for however long it takes, but hopefully it's only one or two, so we should still be okay for time, with your indulgence. Thank you. Warrinder.
Yeah, Ms. Sackman, at the previous session, Real, Carmi, Jones, Casey appeared to accept the Leveson review that jury trials for the most serious indictable offences have more than doubled in hearing time since 2001, but her response was that that was not because of having a jury. Do you agree with that? And if not, why not?
Well, I mean, it is the case that trials are taking significantly longer, and I appreciate the point that was made about where you take the starting point. Sir Brian Leveson's insight is that trials are taking twice as long as they were taking in 2000, and even if one were to take the IFG's assessment of a 50% increase, that of itself is significant. Look, it's not so much whether juries are themselves the driver of the delay, although I've set out why a jury trial may take more time than, say, a judge only for those less serious offences. I think actually your question and the way you phrase it is a useful opportunity just to make the point that, notwithstanding the comment that Sir Ashley just made to me there, of course all those indictable-only offences will continue to have a jury trial. So this is about, as I've said, calibrating the system in such a way that we can ensure that availability of a jury trial is there for those indictable-only offences, however long they need to take, because they are for the most serious offences. But I don't need to establish for my case as to whether this is a good policy, both in terms of its potential for bringing down the backlog and indeed reforming our justice system, for the jury itself to be... No one's saying the jury is the problem. We want to preserve juries for those most serious cases. But at the moment, our system is simply overwhelmed, and the different ways that we get it back to a proportionate, sustainable, workable and critically swift model of justice is by redrawing the line, as previous governments have done, like a Conservative government did in 1988 under the Criminal Justice Act then, when they recalibrated And we've got to get that calibration right in light of the very changes that you described in the previous panel. A totally transformed evidential landscape, a totally different demand profile when it comes to the number of arrests and charging decisions. So, it's unsurprising that a system that was designed in 1971, for all intents and purposes, isn't up to the task of coping with the nature of the cases coming before it in 2025.
Where we will not have a jury is where the expected sentence is going to be 3 years or less. That's going to be the cut-off point.
Yes.
Do you anticipate any problems with that 3-year period?
No. Do you mean in terms of the determination for that?
Yes, yeah.
No, I don't. I think that what we anticipate is a process whereby at the PTPH hearing, where judges are looking at the case management decisions and therefore need to read into the case to understand its nature, its gravity, and the factual matrix that you're dealing with, albeit you're not determining the verdict at that point, to make the sort of assessment that gets routinely made in the magistrates' court in order to allocate cases to a Crown Court bench division is something that judges are well used to, and as Sir Brian Levison observes in his report, can be done in a fairly straightforward fashion as part of that PTPH exercise.
So for those cases where we are currently having trials with jury, not trying to oversimplify the situation, but the jury decides the facts of the case and the judge will advise on points of law. So when these cases will now go to the Crown Court bench division, how do you think that's going to change the role of the judge? And do you think we are moving away from an adversarial position to a more inquisitorial position?
Well, no, I don't think that we're moving away from an adversarial position. I think that the under the new process, as Sir Brian and others have articulated, you will have a Crown Court trial, because we are in the Crown Court after all, in the usual fashion where prosecution will present its case. The evidence will be tested by the defence and so forth. I suppose what changes is that now, where at the moment, as you say, the judge is responsible for giving directions to the jury, that will no longer happen. But in the same way that a judge sums up the facts that have been heard and provides a route to verdict, what you will now have is a judge doing all of that, but then giving the verdict themselves as part of a reasoned judgment. One of the points that was put to me in Parliament the other day, and one of the criticisms is, well, it's going to take an awfully long time because you've got judges having to do something that at the moment they don't currently do in the Crown Court, which is give reasons. I push back on that a little bit. One, for a normative reason, which is that one thing you don't get with a jury is reasons. You don't know how they arrived at that decision, which you will get where you have a judge sitting in the Crown Court bench division. But secondly, just from an efficiency point of view, the judge already has to sum up the case and has to present the route to verdict for the jury, not guide them in any way, but say this is what we've heard. A judge does that anyway and sets out the law and goes through all the structure and sort of elements that you would expect to see in a reasoned judgment. The difference here is, and the only difference I anticipate to the trial that you're describing, is that at the end of it, you'll know why the judge decided what they decided. And if they got it wrong and took into account something that they weren't lawfully permitted to do, then of course that in itself can be the subject of an appeal.
So you don't anticipate the judge having any significant additional burden in performing that role?
No. I mean, I think perhaps politicians are guilty here. You know, we do recognise the significance of these reforms because something as significant is required to address the crisis that we're in. But the radicalism of them can be overstated. This is not a scrapping of all jury trials, far from it. We expect that at least 3/4 of the trials that currently have a jury trial will continue to have them. Similarly, the model that was recommended to us by the independent review of criminal courts is a version or an evolution, if you like, of the Crown Court. It's not a separate, standalone intermediate court with its governed by different rules and procedures and something wholly different. It will be something that is wholly familiar, not just to the legal community, but to other participants in the system too. I grant you the fact that there isn't a jury there is different. And views have been expressed about that. But in terms of the process that will be gone through and the nature of the trial, it will look very similar to, essentially the same as a Crown Court trial conducted today. It's just a division of the Crown Court.
Before I bring in Sarah Russell, Tony Vaughan, in case he had a question.
Thank you, Chair. Ms Ackman, I just wanted to pick up on Mr Juss's point about... I'll make it very quickly, may I, or sure.
I think we have 2 votes. That usually means 25 minutes. But if Tony and Sarah and I and the Minister can get back here, we can start sooner than that. And everybody else will have to make their own route. But yes, we will adjourn now for the votes, and we'll resume as soon as we can, probably about 20 minutes or so. Order. Order, and after the break for voting, we'll resume this afternoon's session of the Justice Select Committee on Criminal Court Reform. We were just about to hear a question to the Minister, Sarah Sackman, from Tony Vaughan, KC.
Thank you, Chair. Ms Sackman, I just want to come back to a question that was raised by Mr Juss, who referred to evidence from one of the previous witnesses that jury times, trial times have doubled since 2001, but it's not because of a jury. Now, I just wanted to ask you, so that kind of increase shows the sort of structural issues that I'm assuming you're saying justify some of these changes. I mean, you've mentioned things like complex evidence, and I just wondered if you could elaborate a little bit on what the other factors are that are causing the structural problems which you're arguing are part of the basis for these reforms.
One of the fundamental things that we have seen over some time now, the backlogs really began to run out of control from COVID onwards, but were already beginning to rise before then, is the increased demand. So increased police numbers, more proactive policing, more proactive charging decisions, the sheer demand coming into the system.
Forgive me, I'm talking about the length of the trials, the times that juries are taking to, or the cases are taking to be resolved, which perhaps isn't about the volume of the cases, but taking any individual case, that they are taking longer each case to resolve. Well, I was just asking what factors are behind that.
So there's a number of things. I mean, we've explored the evidence and the amount of disclosure. So it's quantum, volume of evidence, as well as the nature of that evidence and its complexity. There will be some of the what have been dubbed inefficiencies that were referred to in the previous panel. I mean, I don't want for one second the committee to think that the government isn't cognizant of what the effect of those inefficiencies are and cumulatively the impact they have on the diminution in the amount of hearing time in your average sitting day. So that could be something that does come from the jury. So, for example, a juror is running late, has, is off sick. That can lead to delay.
Does your model attribute delay or attribute elements of apportion these increasing trial times to each of those elements?
So just to complete that point, but that's not the only source of inefficiency. We've heard from the previous panel a major constraint and source of inefficiency is lost time and lost sitting days due to the lack of availability in the workforce. That is a major driver. It's why it's been an area of focus for the government from day one. Reference has been made in other quarters to delays to bringing prisoners up to court and prisoner transfer. Whilst those individually are make a modest impact and therefore would not, if resolved, even of themselves, reduce the backlog. Cumulatively, they are contributing to the increased time that it is taking to dispose of cases. So it's a number of factors at play. But I think the other point to make, and I'll bring in Amy Randall in a moment, the other thing, of course, is that it's this vicious cycle point. As the system reaches a tipping point where the whole system is, if you like, I'm putting it in lay terms rather than in statistical terms, gets gummed up, that of itself leads to a reduction in productivity. It leads to a reduction in things like the early guilty plea, which lead to greater court productivity.
Does your model, you haven't mentioned juries yet in your list of factors that are structural problems, and I was just wondering to what extent your model attributes any responsibility for increased trial times to juries. Because the witness that we heard from before was saying that she doesn't think that increased trial time was because of juries. Now, I was trying to establish the extent to which you say it is or it isn't.
So, as I said in an earlier answer, I don't say, and I don't need to say, that jury trials per se are the primary driver of delay. But within that structure, it is the case that if you take equivalent cases, that could be tried either way, because that's the easiest comparator. It could be addressed in the magistrates before a district judge or lay magistrates, or in the Crown Court. Those cases are processed 4 times faster on average than they are in the Crown Court before a jury. So it's not necessarily, I don't need to establish that the jury trial per se is a driver of inefficiency. We if you like...
I was just trying to understand the extent to which it is part of your case. Whether you need to or not is not my question. It's about whether you do say that it is. And it sounds like you're saying that it does to an extent. Is that your position?
It does to some extent, and I'll bring in Amy here.
Sorry, just to clarify, I think we're saying 2 things: that we accept, as Sir Brian has set out, that jury trials take longer than we think a judge alone deciding the case would. But we don't think that juries are what has led to the rise in how long trials are taking. We don't think somehow that juror behaviour is different now to in the I think it was 2000 was the figure quoted, or I think our statistics show, looking just back to 2019, that cases are taking 70% longer in the Crown Court. We're not saying that's because juries' behaviour has changed in any way. We're attributing that to crime mix, and exactly as the Minister has said, increased disclosure, digital disclosure, more forensics.
The point is the ability of the juries to deal with the evidence that's being presented to them part of the cause for the increased time frames. Is that part of what your case is?
No, I don't think we're saying that, for example, like the deliberation time or the amount of time for the complexity to be set out to the jury is the driver. Just that whether it was a jury or a judge alone, when you're looking at the number of, for example, mobile phone downloads that would need to be provided in a sexual offences case at the moment, they are so much greater than you would have had in, for example, 2000.
Okay. And I wonder actually if it's worth... Chris, because you've been responsible for developing the modelling, which parliamentarians will see, that if you explain that that's based off historic case data of actual individualised cases, I think it's worth explaining, and obviously people will want to unpack that when they see the modelling.
Yeah, I mean, if it's helpful for the committee for me to sort of set out how we are doing the modelling that will be in the impact assessment, in terms of what we model. We'll be looking at the major structural reforms that the government has already announced, so extending magistrate sentencing powers, removing the right to elect, the Crown Court bench division, and appeals and judge-only trials. There are 2 elements of the modelling that I'll talk through, and both are quite important in different ways. One is a specific court simulation model, and the other is dynamic whole system impact modelling, and each of those has a role in sort of understanding the impacts. So, on the specific court modelling, the idea of this is to help understand what a new policy regime would mean for workload in the Crown Court. And to model that, we take a big data set, looking at all the individual cases in the Crown Court, pooled from sort of 2018 to 2024. It's individual level data. And it's got a lot of detail in there. So detail on the offences associated with each case, the pleas involved, custody status, hearing time, sort of etc. A whole range of sort of individual data about each kind of case. What we then do to understand the impact of reform is we simulate proposed policies on that data set. So, for example, you take the sort of 2024 receipts cohort, and you would apply to that what new rules around magistrate sentencing powers might imply in terms of cases not reaching the Crown Court, or for the Crown Court District Bench Division, you would identify the cases that would likely go down that route and apply the assumption around how much quicker they would sort of go through the court. And what that gives you in terms of outputs is effectively a measure within the Crown Court of how individual policies or combinations of policies reduce the number of sitting days required in the Crown Court. And we adjust that data for the future and for what we think the world would look like in sort of 28, 29. Second element of the modelling is the whole system impacts, and that's really important, and it builds on some quite well-established models that the department has already got, that some of you may well have seen before because they're the basis of the prison population projections that we produce. These are essentially whole system models that look at flows through the system from courts to prisons to probation. The reason we use this suite of models is twofold. One is that they are integrated, so it allows us to look at the impact of reforms on the whole of the criminal justice system. The other is it is dynamic, so it takes account of the fact that we know that the world in the future is going to look quite different from the world today in terms of the number and composition of cases coming into the system. And we take the outputs of our specific court modelling and we effectively feed it in as inputs into that sort of bigger modelling infrastructure, which gives us that sort of dynamic and whole system view. So the sort of outputs that will come out from that is we have a view on the impact of various reforms on the workloads in the magistrates and the Crown Courts in terms of number of sitting days they're likely to save. But we also have a view of caseloads. We also have a view of what that would mean for how the Crown Court outstanding caseload is likely to evolve, but crucially what it would also mean for the prison population, what it would mean for probation caseloads as well.
And will you make that entire model transparently public so that Sir Ashley can put in his sitting days into it, which he says are irrelevant, but would actually show what the outputs would be?
So sadly we can't just publish the model and put it out there. That's because it's based on individual level personal data, so it's not as simple as just sort of putting it out there. We're obviously going to be as transparent as we can in the impact assessment about what we've assumed going through it, and are obviously sort of very happy to talk to stakeholders about the detail of how we've done it.
And also just to pick up on that point, we will of course in the impact assessment make clear what our modelling shows will be the sitting day saving from the package of measures. I understand how important that is to the committee and we will make that clear.
Yeah, and just finally on that point, I mean, Sir Ashley is no longer here, but I've been very clear as the government minister in terms of how we've directed officials not to overclaim for the modelling. I don't want to overclaim for the modelling. We need the modelling because it is what tells us whether this is going to work or not. And I am very concerned with that because that's why we're all here. But what we're not going to do is overstate the individual savings of individual measures in order to justify them. I'm very clear that it's the interaction and the whole package of reforms, as I said earlier, that delivers the reform and the outcome that we want to see, which is bringing down the backlog by the end of this Parliament. So, you know, if people are expecting the model to be the entirety of the answer or the justification for this policy, they're going to be disappointed. It's a component in making the case for these reforms, and equally it has to be and should be looked at as a whole in terms of the cumulative time savings and the systemic behavioural changes that flow from that.
Is the systemic change not factored into the model? I mean, does the model not need to assume this behaviour change?
It would be great if it did, but I would rather that what we present is a conservative estimate for what we can achieve, rather than guessing and hoping for the best that all of a sudden, because one no longer has the right to elect, that's going to generate loads of early guilty pleas because that suits my case. I'm not going to do that. I'm going to argue from what we know, the individual case data, what we know about projected demands and caseload, both in the magistrates and the Crown, to present as transparently as possible to Parliament the basis for why this is a good, workable set of reforms to fix a broken system.
Right, we have less than half an hour. I've got
really I'll endeavour to keep my answers short. That was an important point.
Yeah, we're going to have to be much tighter if we're going to get through what we want to get through. But you go.
Just very quickly, so that I am clear in my own mind, there is no issue about jury trials taking longer because juries are taking more time to consider, and also with their deliberations, with the cases becoming more complex, with additional disclosure to consider as well, and that therefore there would be a time saving by just having a judge-only trial.
That's not an assumption that we have made, although when it comes to...
It's not an issue for you? Am I correct in thinking that?
No.
Really quick question, just sticking on modelling, but a slightly different angle to it. So there's been a lot of focus on the length of time that a jury trial takes and the consequence or lack of consequence on the backlog. Has there been any modelling or has there been any consideration about other factors of jury trials and the impact on the backlog? For example, the comparative flexibility between a Crown Court judge sitting alone and a jury trial. So I'll give you one example of maybe two examples. Maybe there's a tummy bug that sweeps through the jury has to be discharged entirely. If a judge gets a tummy bug, he might be able to return to the case in a week's time and pick the case up and not have to start the trial again from scratch. Or if a key witness becomes unavailable, they suddenly have to have a routine operation, they're going to be out of action. Similarly, the jury would have to be discharged entirely and the trial would have to be relisted and started from scratch on another day, probably in months or years to come. So I just wondered if there'd been any modelling looking at that more flexible approach.
Chris will correct me if I'm wrong, but in answer, I suppose it picks up on the previous question. That's not something that we've factored into the modelling. It might be part of the time saving that's realised. I mean, the example going back to the previous question in relation to complex fraud cases, it's possible to imagine that in a world where, as here, we pick up on the IRCC's recommendation to move to judge-only trials for complex fraud, that part of the time saving doesn't just simply come from having one decision maker rather than a jury of 12, but the fact that you've got complex material which can be marshalled more in a more time effective way and imposing less of a jury burden. But I don't think we've got in the modelling down to that level of granularity, but I'll be corrected if I'm wrong.
No, we don't have to that level of granularity. I mean, in Sir Brian Levison's work, when he was looking at how much the district bench, for example, might save in efficiency terms, that 20% figure is a sort of broad brush, kind of all-encompassing figure that is trying to capture all the different factors that might contribute to greater efficiency. So it's implicit in that, but we haven't looked at that sort of specific factor.
That could be bonus time savings then, essentially.
It could. Indeed it could.
What is the difference between the modelling the MOJ are currently doing on this and the modelling that Levison's team did, in a nutshell?
So I mean, look, it's very similar in terms of approach. A few differences. So one will be that the MOJ's analysis is going to be based on an updated set of underlying projections for the criminal justice system. So this is sort of not the modelling of reform, but it's the modelling of what would happen in the absence of reform. And since Sir Brian reported, we published a new set of projections, so we'll re-baseline to that work. We've since he did his report, we've continued to refine the modelling that we do of the court system and the kind of court modelling I talked through earlier to use more granular data and use more of that micro data to get if you like, a finer picture of the impact of reforms. And obviously as well in some cases we're modelling sort of slight variance on the policies that he recommended. But it's very similar in terms of the way it's constructed.
If this is public data, why can't it be anonymised and shared in terms of the model that you're using?
So in terms of the model, I mean, it is sort of detailed individual court level data. I don't think we can just anonymise it. We would need to make sure that you can't identify individual cases within that data. I think, but we can sort of get back to you on that if that's helpful.
On that point, surely you could take out the identification of the court level stuff, aggregate it all together, and then that would be inherently more anonymising.
I mean, we need. Sorry.
But perhaps as a first, we totally understand the desire from the committee to see the data, and I think if we publish the impact assessment alongside ahead of a bill, then we'll be more than happy to come with follow-up questions. And if actually there are data sets that you think it would be useful for you to dig into, then we can discuss that once you've seen what it is that we're proposing to put out.
Sarah, did you have another?
Thank you. In terms of the substantive proposals around Levison's recommendations, his recommendation was for the Crown Court Bench Division to be constituted by a judge sitting alongside two magistrates. The government's position is that the new Crown Court Bench Division will be a single judge only. In terms of, Levison said that magistrates would bring local community values and a measure of local accountability in a similar way to that provided by judges. Sorry, juries, thank you. In terms of the position around judges, historically, and on an ongoing basis, there have been very significant concerns that the judiciary produces racially differentiated outcomes for different groups. The Lamy review was very concerned that black defendants appeared to be getting longer sentences than their white peers. The Sentencing Council's very contentious recommendations last year were an attempt to deal with that problem. Whether or not people agreed with them, that was what they were looking to remedy. And further, subsequent to the Lamy report, there has been another piece of academic research from the University of Manchester in which a professional survey of solicitors and barristers found that the survey of 373 legal professionals found that 56% stated they had witnessed at least one judge acting in a racially biased way towards a defendant, while 52% had witnessed discrimination in judicial decision-making. There is significant long-term evidence of discrimination in judicial decision-making. In view of that, why does the government propose to go ahead in a version of these reforms that doesn't involve the additional protection of magistrates?
So you're right to draw attention to disproportionality and racial disparity right across the criminal justice system. It's something that when I set out plans for comprehensive reform of the criminal justice system, it's one of the areas in which I think we should be looking for every opportunity to address that. And it's not just in courts, of course, but the CPS recently published its own report and findings of disproportionality in charging decisions. One of the things that the Lord Chancellor said in his Lamy review, and more recently, is that transparency is the best disinfectant when it comes to racial disparity. So in that regard, one of the things that we are looking to take the opportunity to do in this reform, as well as the Equalities Impact Assessment, which we will present to Parliament, is to embed monitoring of outcomes and that in itself assess whether there is racial disparity. The second thing I would say is our judges, I have confidence in them. And the fact that they need to give reasons for their verdict, again, is another source of transparency. If you've got to justify your decision and explain how you got there, that sheds light on how that result has been reached in a way that one doesn't currently have with a jury. I think the other factor is that we know that in other jurisdictions where the judge alone model operates, the Canadian one is the one that I've researched to the greatest extent. It's one in which fairness is maintained, notwithstanding the fact that it's judge alone, and they have, the alternative systems running in parallel. And the view there is that fairness in relation to this is maintained. We of course have judge alone for other sorts of very serious cases, whether it's our youth courts, family courts, and we trust in them to do a good and independent job. But I think that things like monitoring and things like a requirement to give a reasoned judgment will assist.
With the greatest respect, judges currently have to give reasons for their sentencing decisions. Nonetheless, we see disproportionality in sentencing decisions, which would suggest that having to give reasons alone is not going to solve this problem. What David Lamy did find in his review was that what was best for solving this problem was juries.
So I think that reasons in not just in judicial decision making, but in public decision making, having to justify why you've reached the conclusion, the decision you reached, people may not like the decision, is actually a really important component of open justice and transparency, and it's also open, of course, to challenge via appeal. I think that monitoring will assist. And as I said, we entrust our judges to take decisions. Look, it's hard to think of a more serious decision than depriving someone of their liberty, but of course, removing children from an individual's care is also a draconian and serious thing. These are the sorts of decisions that we entrust our judges to take on a daily basis, and I think that's where monitoring and equality impact assessment ongoing as part of these reforms will actually shine a light in a way that we don't have to quite the same extent at the moment. And one other point, just on the racial disparity, I think it's a great question, because racial disparity in our criminal justice system is a very serious issue. But the other thing that's a serious issue is racial disparity in crime, and the fact that black people and Asian people in this country are disproportionately the victims of crime. The fact that you are 4 times more likely to be a victim of a homicide if you're black than if you're white, that obviously I think troubles all of us. And obtaining swift justice for those victims too is a crucial objective of these proposals.
I absolutely agree with that point, but I don't see that the defendants from ethnic and religious minority backgrounds should have to their entitlement to a fair trial should not be sacrificed because they're also from groups that happen to be disproportionately more likely to experience crime. Absolutely, they must be protected in both respects and not one or the other.
I absolutely take that point, and I suppose my contention is that the fairness of the trial that they would receive within the CCBD, in the same way that the trial that they would receive in the magistrates' court or before a jury, should be fair regardless and can be fair under the CCBD. And what we want to do is look at fairness right across the criminal justice system.
Did you want to come in briefly?
Yes, because magistrates are chosen from a wider pool of people, do you accept that magistrates will bring a level of diversity and that community experience that judges alone will not bring? And that is probably the reason why Brian Leveson suggested that the bench division should be a judge and 2 magistrates.
I mean, that is why he suggested it. It's set out in his report, and I was pleased to observe the panel earlier when the previous speaker from the Magistrates Association was saying that these proposals taken as a whole are a vote of confidence in our magistracy. And you're right. Our magistrates provide that lay element, the connection to local justice, and they do provide diversity. It struck me looking into the figures that when you look at the educational backgrounds of magistrates, north of 60% are state educated, the fact that in London 31% of magistrates are black or minority ethnic, these are positives. And it's why we're entrusting the magistracy to take on not just a greater volume of cases, but a greater complexity of cases under these reforms taken as a whole. But that in and of itself doesn't necessarily mean that we ought to. We're asking them to do a lot, of course, under the proposals with increased sentencing powers and with the removal of the right to elect. But I think the model that follows the Canadian model of judge only for this actually relatively narrow cohort of cases, likely 3-year sentence, exceeding those that can be dealt with by the magistrates, can be dealt with fairly by a judge, monitored and providing reasons and transparency.
I want to deal with magistrates' powers briefly before we end, and I've got, I think, Lindsay Farnsworth and Tony Vaughan. Do you want to?
I might have to go in about 2 minutes.
You can ask a question and I'll hand over to Tony.
Yeah, I was going to focus on the magistrates' court aspect to the changes. The Leveson report talked about removing the right to elect Crown Court trial for certain low-level offences, but the government has actually decided to go further than that. I just wondered if you can explain the rationale for that decision.
I can. We looked at the modelling of the impact of the reforms that the IRCC proposed, and so part of the reason was that they didn't achieve in full the aim that we've got here, which is to bring down the delays and the waiting lists to a sustainable level and to keep them there. So that was part of the reason. The other part of the reason, and I know that Sir Brian Leveson has expressed support for this view, albeit it wasn't contained within the report, is the principled reason that I outlined earlier about putting the determination of mode of trial in the hand of the court rather than the defendant. and that being not just a principled but a more simple and clear way, rather than entering into a situation where you're trying to recategorise certain offences, which is what was being suggested by, I think it was the chair of the Bar Council. You know, where do you draw the line on certain offences? Why some and not the other? What's the principal basis for that? What we've got here is a key measure that will enable this package of reforms to work, and it's principled in terms of balancing the system and the election mode of trial in the interests of justice, away from the defendant, but more towards justice itself, and I think indeed in terms of the interest of victims as well.
Tony Moore.
Thank you, Chair. Ms Ackman, I just want to ask about appeals. So the proposal is that there would appeals from the Magistrates' Court to the Crown Court. Is the proposal that a judge alone will hear both permission to appeal and the appeal itself? And does your modelling factor in the time that those stages would take?
I actually like the Sir Brian's report provides an excellent kind of flowchart on the appeals process in chapter 6, and his model is the one that we're following. The difference being, as you've said, that he suggests a judge and 2 magistrates. We're suggesting a judge, and what we're trying to do here is make it so that you don't have the unfettered kind of access to the Crown Court. We're introducing a permission stage, so that there have to be a grounds for appeal. So is the appeal reasonably arguable? Is the test. To answer your question, it will be a judge alone that decides on the papers on that point, and then has a hearing that again is judge alone. That is a hearing where that specific point is considered, and then it's obviously up for the judge alone to then decide on the course of action, be that dismissing the appeal, be that a retrial in the magistrates. But yes, it is a judge alone.
And that all presupposes that you've got transcripts of the proceedings below. Are you confident that you've got the technology in place to be able to do that quite easily?
We've committed to that. Yes, that was part of the talk about the investment piece. Clearly that's predicated, the ability to do that, on having the audiovisual equipment to make recordings of the magistrates' hearings and transcription where that's needed. And so yes, and that is something that we've committed that investment. Look, of course I am determined that these reforms come forward through legislation, but again, and to give them their due, the Institute for Government recognised this in the earlier panel. We are not waiting for this forthcoming bill to grip the crisis in our courts. We're making that investment already, and of course the appeals model that follows from the IRCC recommendation has to have those recordings. We're ensuring that they are that the kit that's necessary is already there in every magistrates' court right across the land, so that we can do this properly.
And will legal aid cover permission to appeal? Because there are some jurisdictions where you don't get paid unless you do get permission to appeal. Would you ensure that they do in any event, so as to mitigate any of the concerns about the reduction in rights from changing the appeal rights?
So I think that's something we'll have to take away and look at and make sure that there is no barrier to access to justice. But I'm not going to commit to that right away, but I will take away that point.
If I may, just on the modelling around this measure, it's worth saying I wouldn't consider it kind of a big ticket item in terms of sitting day savings. Like, there is something, and we will show that in our modelling. But I think to earlier discussion in this session around how you reform the system to look at triage and where cases are dealt, and this not being a pick and mix, as Sir Brian talks about, in a world in which you are removing the right to elect, to then maintain the same appeal route so that you can automatically go to the Crown would seem incoherent. But it's worth being clear in our modelling that even though, as was discussed on the previous panel, the proportion of appeals from the magistrate is pleasingly very, very low, showing that people, I think, are, as the previous panel member was saying, people are confident in the justice they receive there. a little under half of those are upheld. Our modelling doesn't presuppose that proportion change, that number changes, that appeals upheld under the current system would still be upheld now.
And one very further brief point, if I may, on this. This was a recommendation of the IRCC. We think it's a good idea. We're not claiming that it makes a huge time saving, but we think that it fits with this principle around proper triage. And the other thing it does is, of course, where a mistake has been made, there should be available right of appeal, and we see the success rate there. But we also know, and this is an observation of the IRCC, that there is a proportion of cases where the appeal is upheld partly because at the moment there's an automatic rehearing. Victims and witnesses don't want to go through it again. They withdraw, and so the appeal is upheld. And so part of this, you talk about creating a better system on a principle basis, about reducing the burden on victims and witnesses. It's an observation that's been made by the Victims Commissioner, and she's right about it.
I think the answer to the question that was asked of the earlier witnesses and they weren't able to provide an answer to, I think it would be really useful for us to have that information in due course, the number of these kinds of appeals that end up being resolved in the appellant's favour because witnesses don't turn up, I think would be very useful.
Thank you very much. This is perhaps an unintended consequence, but I think it's an important question. The previous government reduced magistrates' sentencing powers to 6 months from 12 months because it said that data indicates that increased magistrate sentencing powers has a negative short-term impact on the prison population. You're intended to double it again, perhaps up to 24 months. What have you factored in for the increase in prison population there?
Well, what I can say, and I might defer to those on either side of me in terms of to give a precise answer about what's been factored in. Two things I'd say. One is the evidence that we have in terms of the timeliness gain, the timeliness of the overall reduction in the waiting list, if you like, or backlog as a result of extending magistrate court sentencing powers. It's a useful tool in that regard, and it's why we're pursuing this here. The second thing, of course, is that it's a really good question because you've got to look at what the impact will be, particularly at a time when these reform measures are interacting with the reforms in the sentencing bill, and so it's that interaction that we've had to look at. But I'll turn to Chris and see to illuminate on that.
I mean, further to what I was saying earlier, Chair, this is one of the reasons why we want to look at this in a kind of whole system way, and why we plug in the impact of court reforms into this kind of whole system suite of models, is so that you can actually see how, if you divert a certain number of cases that were currently in the Crown Court to the Magistrates' Court, they progress through at a different pace, what that would mean for the prison population. So we do look at that as we look at the effects of the policy. We're going to conclude. We're very grateful for the time. I'm just going to throw one final curveball at you, which is we got a long-awaited, lengthy reply. It's now been published this afternoon from the Home Secretary in relation to the reforms of the first-tier immigration.
Can you repeat
in relation
question?
to the first-tier immigration tribunals. Yes. Very significant changes. There's some more. It begs many questions. It answers. This is a Home Office lead. Clearly, it's a switch from a judicial to an administrative process for determining appeals, at least in the first instance. So, what is your role going to be as the Minister for Courts and Tribunals, in what is leaving aside the Home Office's intentions on speeding up immigration processes? This is a significant change for an important part of the judiciary. So what's your role here?
Well, look, as the Home Secretary's confirmed to you, there is this intention for there to be a transition from the first-tier tribunal, the IAC, to a new independent adjudicator in a phased approach. And no doubt the Home Secretary will share more detail with the committee in due course. I understand that there are plans for the Home Office to introduce legislation later this year. Our role in this will be to ensure that there is a smooth transition, particularly where you've got dual running and you've got the existing system. And I do want to commend the role that our immigration judges play. I had the good fortune to visit fairly recently the tribunal in Rosebery Avenue. I'm well aware, particularly at the current time of the climate in which our immigration judges and practitioners are operating. And they do a great job. They're also an innovative jurisdiction in terms of using transcription services and others elements to attempt to get through the backlog of cases in that jurisdiction. So our job in this will be to support the Home Office in the implementation of the plans to ensure that's done fairly and promptly and efficiently, and working hand in hand with the judiciary to achieve the changes that will come forward.
You're comfortable, and the MOJ is comfortable with a reduction in judicial powers and judicial role here.
It's an alternative model. I'm not going to comment further without having the detail in front of me, but it's an alternative model and one with merit, and it's about a system that works, an immigration system, an asylum system that works. It's not about, I don't see it through the lens of a reduction of judicial powers. You will always have the High Court and the Upper Tribunal as a backstop, but this new model, which the Home Secretary is bringing forward, is one that we stand ready to support.
Minister, thank you very much. Thank you for your time. Thanks to all our witnesses, some of whom have stayed the duration. I'll end the session there. Order.